Welcome, everyone. Tonight, we've got the sixth session of our book club, Reasoned Argument, the Counter to Cancel Culture. Tonight, we're going to focus on the Virginia ratification debate. It's a great debate between Patrick Henry and James Madison. In the assignment, I had mentioned the Burke-Paine debate, but we're going to put that off until next week. Regarding the debate between Henry and Madison, Madison's biographer Joseph Ellis writes, even more than the Lincoln-Douglas debate over slavery or the Darrell Bryan debate over evolution, both of which we'll look at later, the Henry-Madison debate in June of 1788 can lay plausible claim to being the most consequential debate in American history. Why? Well, first of all, at this point, the Federalists had won 8 states already. So all they need is 9. This is the 9th state. If they win Virginia, then the Constitution has been approved. But the Federalists have got a harder time here. Why? Well, they're up against a stronger team. Think any sports team. You got the best and the brightest in this one. So Madison's there, yes, but on the other hand, the great orator, Patrick Henry. And they each have a backup. Henry has George Mason, who refused to sign the Constitution. He was in the Constitutional Convention and contributed, but wouldn't agree at the end for lack of a Bill of Rights. But we also have Edmund Randolph, who was at the convention and who likewise would not sign. And he's on Madison's side. So we've got the A team on both sides. And Henry could have gone to the convention, but he turned it down and he said he smelled a rat. Interesting in terms of what his tactics were. But what we've done, as from the last session, is we actually skipped over the Constitution itself. So this is a debate about the Constitution in ratification. But what really were the stakes? That is, the Anti-Federalists had a very different view, obviously, than the Federalists. So which is it? Because even today, I know that there are conservatives who talk about the Constitution as being too powerful. Well, let's hear from Justice Scalia.
There is really nothing like it in the world. It is not a great Constitution simply because it's our Constitution. There is no Constitution like it in the world, and there never will be. Never again in the history of mankind will a governing document be put together not by political parties figuring out how to parcel out the power the best way or by conquering armies, but by a May, June, July, 4-month seminar attended by the most prominent people in the country, which is how this document came to be. It will never happen again.
Justice Scalia said that we couldn't have another convention like this again. Well, there are a number of reasons why not, but one of the biggest is secrecy. Well, why does that matter? It has all the impact on the audience. That is, in the Constitutional Convention itself, they were deliberating, they were talking to each other. Yes, they had one eye on what the ratification fight would be, but they weren't posturing the way members of Congress do today and have done for a long time. They could actually deliberate. Now, when we go into the Virginia ratification debate, that's different. It's not a deliberation, it is a debate. And it's not only the members who are there, the public is there listening, as they have every right to be. So that the orators involved, Henry and Madison, they have different eyes for their audience. Now, Henry's includes the public audience. I don't know how much Madison is concerned about the public audience. Why? Because they know the vote is close. Some say it was tied, others say the Federalists had a large edge. I'm sorry, not a large edge, a small edge. In any event, there were very few electors who were actually undecided at this point. So they may be speaking to different audiences. So here are 3 think points for tonight. 1, Henry versus Madison on states and the people. 2, Henry versus Madison on democracy and republicanism. And 3, Henry versus Madison on a Bill of Rights. In part 1, that's where we're going, obviously, Henry versus Madison on the states and the Bill of Rights. So we're going to listen to Patrick Henry. He had a very long speech, so we're only going to be able to take parts of it, but I'm trying to match the debate. We'll have one part from Henry, we'll have a response from Madison, we'll go back to Henry, we'll have a response from Madison. That's the way we'll proceed. You'll remember that Henry's speech at the time of independence was his "Give me liberty or death" speech. Now, this speech is called, or given the name, "Shall liberty or empire be sought?" That's the basic debate going on here. Let's listen to Henry.
I have the highest veneration for those gentlemen. But, sir, give me leave to demand, what right have they to say, "we the people"? My political curiosity, exclusive of my anxious solicitude for the public welfare, leads me to ask, who authorized them to speak the language of "we the people" instead of "we the states"? States are the characteristic and the soul of a confederation. If the states be not the agents of this compact, it must be one great consolidated national government of the people of all the states. I have the highest respect for those gentlemen who formed the convention, and were some of them not here, I would express some testimonial of esteem for them. America had, on a former occasion, put the utmost confidence in them, a confidence which was well placed, and I am sure, sir, I would give up anything to them. I would cheerfully confide in them as my representatives. But, sir, on this great occasion, I would demand the cause of their conduct. Even from that illustrious man who saved us by his valor, I would have a reason for his conduct. That liberty which he has given us by his valor tells me to ask this reason. And sure I am, were he here, he would give us that reason. But there are other gentlemen here who can give us this information.
Note that Henry starts out very respectfully. He has the highest veneration for his opponents. But you must know that he is seething inside. He's a man full of passion. And this isn't just an ordinary argument for a client. As far as he is concerned, he's losing his country. It's not surprising then that he really explodes with passion. Who authorized you to speak in the name of "we the people" instead of "we the states"? This gets to the heart of it. It is a transformation. Really, it's a revolution in one sense, going from the Confederation to this new invention that nobody has ever seen before. So, who has the burden of proof in this? Ordinarily, it should be on the proponent of change. Watch to see as we go through, and it will be overall on Madison, and for that reason, we're going to give him more time and space. But watch what happens in terms of the interplay when Madison comes back. But that's not coming just yet. We're going to hear a little bit more from Henry before we go to Madison.
The people gave them no power to use their name. That they exceeded their power is perfectly clear. It is not mere curiosity that actuates me. I wish to hear the real, actual, existing danger, which should lead us to take those steps, so dangerous in my conception. Disorders have arisen in other parts of America, but here, sir, no dangers, no insurrection or tumult have happened. Everything has been calm and tranquil. But, notwithstanding this, we are wandering on the great ocean of human affairs. I see no landmark to guide us. We are running we know not whither. Difference of opinion has gone to a degree of inflammatory resentment in different parts of the country, which has been occasioned by this perilous innovation. The Federal Convention ought to have amended the old system. For this purpose, They were solely delegated, the object of their mission extended to no other consideration. You must, therefore, forgive the solicitation of one unworthy member to know what danger could have arisen under the present Confederation, and what are the causes of this proposal to change our government.
He has to say the people gave you no power because at this point, 8 states, through the people acting in convention, they've approved this new document. And he's also been operating on the assumption that the people at any time are able to change their form of government. So he's moving into areas where he's actually setting up the response from Madison. Now, in this section, he says there is no power, yes, but what he's talking about is from the first segment that we just heard, and that is, if it's not a confederation, what is it? It's got to be a consolidation. And that's what really worries him and has always worried the Anti-Federalists and is a worry today. So let's go on and listen to what Madison has to say now.
Professions of attachment to the public good and comparisons of parties ought not to govern or influence us now. We ought, sir, to examine the Constitution its own merits solely. We ought to inquire whether it will promote the public happiness. Its aptitude to produce this desirable object ought to be the exclusive subject of our present researches. In this pursuit, we ought not to address our arguments to the feelings and passions, but to those understandings and judgments which were selected by the people of this country to decide this great question by a calm and rational investigation. I hope that gentlemen, in displaying their abilities on this occasion, instead of giving opinions and making assertions, will condescend to prove and demonstrate by a fair and regular discussion. He told us that this Constitution ought to be rejected because it endangered the public liberty, in his opinion, in many instances. Give me leave to make one answer to that observation. Let the dangers which this system is supposed to be replete with be clearly pointed out. If any dangerous and unnecessary powers be given to the general legislature, let them be plainly demonstrated. And let us not rest satisfied with general assertions of danger without examination. If powers be necessary, apparent danger is not a sufficient reason against conceding them.
So Madison is the perfect foil for Henry, whereas Henry's very passionate, Madison is anything but. And what he starts out with is to say, this shouldn't be argued in terms of the passions. We have to be calm and deliberate. Yes, and that's what he's going to do. He's going to go heavily into the logic. He has to. This is something new. It has to be explained. It's been explained in the Federalist Papers, but not everybody's read that. And he has to go point by point, but he's setting the stage here very calmly.
I must confess, I have not been able to find his usual consistency in the gentleman's argument on this occasion. He informs us that the people of the country are at perfect repose, that is, every man enjoys the fruits of his labor peaceably and securely, and that everything is in perfect tranquility and safety. I wish sincerely, sir, that this were true. If this be their happy situation, why has every state acknowledged the contrary? Why were deputies from all the states sent to the General Convention? Why have complaints of national and individual distresses been echoed and re-echoed throughout the continent? Why has our general government been so shamefully disgraced and our Constitution violated? Wherefore have laws been made to authorize a change, and wherefore are we now assembled here? A federal government is formed for the protection of its individual members. Ours has attacked itself with impunity. Its authority has been disobeyed and despised.
Madison has already challenged Henry by asking him earlier, where are the examples of all this danger that you're talking about? So then he begins this part by saying, I must confess. He's finding inconsistencies in Henry's argument, and he's picking them apart. The first one has to do with the question of dangers. And Henry is asked for examples. And he talks about the fact that it's occurring in other states. Henry may not realize it. he may be only focused on Virginia, but those in the convention and Madison, they're focused on the other states as well. That is the role appropriate for government, he says. So this picking apart of inconsistencies, which is typical of good lawyering, is what we just heard. But there's also then going to be another section coming up right now where he goes into the second of the inconsistencies.
I think I perceive a glaring inconsistency in another of his arguments. He complains of this Constitution because it requires the consent of at least 3/4 of the states to introduce amendments which shall be necessary for the happiness of the people. The assent of so many he urges as too great an obstacle to the admission of salutary amendments, which, he strongly insists, ought to be at the will of a bare majority. We hear this argument at the very moment we are called upon to assign reasons for proposing a constitution which puts it in the power of the 9 states to abolish the present inadequate, unsafe, and pernicious confederation. In the first case, he asserts that a majority ought to have the power of altering the government when found to be inadequate to the security of public happiness. In the last case, he affirms that even 3/4 of the community have not a right to alter a government which experience has proved to be subversive of national felicity. Nay, that the most necessary and urgent alterations cannot be made without the absolute unanimity of all the states. Does not the 13th article of the Confederation expressly require that no alteration shall be made without the unanimous consent of all the states? Could anything in theory be more pernicious, improvident, and injudicious than his submission of the will of the majority to the most trifling minority? Have not experience and practice actually manifested this theoretical inconvenience to be extremely impolite? Let me mention one fact which I conceive must carry conviction to the mind of anyone. The smallest state in the Union has obstructed every attempt to reform the government. That little member has repeatedly disobeyed and counteracted the general authority, nay, has even supplied the enemies of its country with provisions. 12 states had agreed to certain improvements which were proposed, being thought absolutely necessary to preserve the existence of the general government. But as these improvements, though really indispensable, could not by the Confederation be introduced into it without the consent of every state, the refractory dissent of that little state prevented their adoption. The inconveniences resulting from this requisition of unanimous concurrence and alterations in the Confederation must be known to every member in this convention. It is therefore needless to remind them of them. Is it not self-evident that a trifling minority ought not to bind the majority? Would not foreign influence be exerted with facility over a small minority? Would the honorable gentleman agree to continue the most radical defects in the old system because the petty state of Rhode Island would not agree to remove them?
Well, there are some problems with what Henry is arguing, and Madison points them out rather well. Besides Madison's statement about Henry using or resorting too much to emotion, passions, etc., the real points have to do with the logic. That is, the logic of structure. So first, while Henry says that really everything's wonderful, maybe everything is wonderful in Virginia, but what about the other states? There are problems in the other states. Who is going to protect the other states? And in the other states, Virginia has no obligation, or at least no enforceable obligation, to help them. The point is that what you have are 13 governors. You have 13 states. They are not working together well, internally or externally. That's the first thing. But the second thing is actually even more fundamental, and that is Henry is referring to, and we'll discuss more in the next clip, democracy, majority. Well, there's a majority maybe in each state, but in the Confederation, it's not governed by majority. Changes have to be made unanimously. So in effect, any one state, and he's referring to Rhode Island, can hold everything up. So when you're talking about only 9 states to ratify the Constitution, he's saying that that's not enough. Madison is saying, well, in fact, the population in those 9 states is more than the majority, and the number of states is more than the majority. So the argument gets difficult in terms of confederation or federalism always. It doesn't work out to simple majoritarianism. But let's turn now to the next slide. So in this second section, Henry versus Madison on democracy and republicanism, let's first of all hear from Henry again.
What, sir, is the genius of democracy? Let me read that clause of the Bill of Rights of Virginia, which relates to this. Third clause, that government is, or ought to be, instituted for the common benefit, protection, and security of the people, nation, or community. Of all the various modes and forms of government, that is best, which is capable of producing the greatest degree of happiness and safety, and is most effectually secured against the danger of maladministration, and that whenever any government shall be inadequate or contrary to those purposes, a majority of the community hath an indubitable, unalienable, and indefeasible right to reform, alter, or abolish it in such manner as shall be judged most conducive to the public weal.
Okay, so Madison and Henry agree on the end of government. That's not the problem. The question, as we've seen before, especially when we talked about John Adams, was what form will get us there? And that's where the fundamental disagreement is. And Henry is saying, well, people have the right at any time to change their form of government. That, as I've already said, undercuts his whole argument. But on the other hand, the Federalists are saying that's an unstable, oppressive situation. Let's listen to the second part of Henry now on this clip.
This, sir, is the language of democracy, that a majority of the community have a right to alter government when found to be oppressive. But how different is the genius of your new Constitution from this? How different from the sentiments of free men, that a contemptible minority can prevent the good of the majority? If then, gentlemen, standing on this ground, are come to that point, that they are willing to bind themselves and their posterity to be oppressed, I am amazed and inexpressibly astonished. If this be the opinion of the majority, I must submit. But to me, sir, it appears perilous and destructive.
Here's the majoritarian problem. It may be that state by state you have a majority, but how do you get them to work together? Neither side wants a complete national majority in the sense of a mass vote by the whole population. They still want the states. So how do you make them work together? That's the whole problem. That is exactly what the summer of 1787 was all about. In that seminar Justice Scalia talked about, they had to work it out. It had never been done before. They are inventing a new structure. So let's hear from Madison.
Give me leave to say something of the nature of the government, and to show that it is safe and just to vest it with the power of taxation. There are a number of opinions, but the principal question is whether it be a federal or consolidated government. In order to judge properly of the question before us, we must consider it minutely in its principal parts. I conceive myself that it is of a mixed nature. It is in a manner unprecedented. We cannot find one express example in the experience of the world. It stands by itself. In some respects, it is a government of a federal nature. In others, it is of a consolidated nature. Even if we attend to the manner in which the Constitution is investigated, ratified, and made the act of the people of America, I can say, notwithstanding what the honorable gentleman has alleged, that this government is not completely consolidated, nor is it entirely federal. Who are parties to it? The people. but not the people as composing one great body, but the people as composing 13 sovereignties. Were it, as the gentleman asserts, a consolidated government, the assent of a majority of the people would be sufficient for its establishment. And, as a majority have adopted it already, the remaining states would be bound by the act of the majority, even if they unanimously reprobated it. Were it such a government as is suggested, it would be now binding on the people of this state, without having had the privilege of deliberating upon it. But, sir, no state is bound by it, as it is, without its own consent. Should all the states adopt it, it will then be a government established by the 13 states of America, not through the intervention of the legislatures, but by the people at large. In this particular respect, the distinction between the existing and proposed governments is very material. The existing system has been derived from the dependent derivative authority of the legislatures of the states, whereas this is derived from the superior power of the people. If we look at the manner in which alterations are to be made in it, the same idea is, in some degree, attended to. By the new system, a majority of the states cannot introduce amendments, nor are all the states required for that purpose. 3/4 of them must concur in alterations. In this there is a departure from the federal idea. The members to the National House of Representatives are to be chosen by the people at large, in proportion to the numbers in the respective districts. When we come to the Senate, its members are elected by the states in their equal and political capacity. But had the government been completely consolidated, the Senate would have been chosen by the people in their individual capacity, in the same manner as the members of the other house. Thus it is of a complicated nature, and this complication, I trust, will be found to exclude the evils of absolute consolidation, as well as of a mere confederacy. If Virginia was separated from all the states, her power and authority would extend to all cases. In like manner, were all powers vested in the general government, it would be a consolidated government. But the powers of the federal government are enumerated. It can only operate in certain cases. It has legislative powers on defined and limited objects beyond which it cannot extend its jurisdiction.
So what Madison is saying here is essentially what he says in Federalist number 39, that what we have is partly federal and partly national. He calls it a composition or a compound republic. But what happens over time is that our compound republic becomes the new definition of federalism, meaning a federal state. Back then, confederalism and federalism meant the same thing. Since our Constitution and the Federalist Papers, they don't mean the same thing. Confederation means what we had before under the Articles of Confederation. What we mean by federalism is what we have under our Constitution. Other countries that have tried federalism have different forms of federalism, not the one that we have. As Madison also points out, Virginia is not bound at all until it itself has, by majority vote, decided to enter under this Constitution. At that point, it doesn't give up all of its powers, it gives up some of its powers. What it is retained are the essential powers of governance. Now, some conservatives, many conservatives indeed, will complain, and understandably so, that in fact the states have lost over time much of the powers that they were left with. Yes, that's happened. Part of it has been by federal overreach, yes, much of it indeed. But also remember that the things that most affected us were two amendments put forward by progressives, but passed by the people. The 16th Amendment on taxes and the 17th Amendment on direct election of senators, a democratic move that actually hurt our understanding of federalism and made the government more consolidated. All of this is a movement by progressives that we'll discuss more at the last session, a movement towards consolidated power. That is what is wanted, but so far it has been at least partially thwarted. Remember last time I talked about the Leviathan and how the administrative state is building towards that in many ways. And Madison, in the next clip, is going to admit that if certain things happen, there would be consolidated power. So pay attention to this.
But the honorable member has satirized with peculiar acrimony the powers given to the general government by this Constitution. I conceive that the first question on this subject is whether these powers be necessary. If they be, we are reduced to the dilemma of either submitting to the inconvenience or losing the Union. Let us consider the most important of these reprobated powers. That of direct taxation is most generally objected to. With respect to the exigencies of government, there is no question but the most easy mode of providing for them will be adopted. When, therefore, direct taxes are not necessary, they will not be recurred to. It can be of little advantage to those in power to raise money in a manner oppressive to the people. To consult the conveniences of the people will cost them nothing, and in many respects will be advantageous to them. Direct taxes will only be recurred to for great purposes. What has brought on other nations those immense debts, under the pressure of which many of them labor? Not the expenses of their governments, but war. If this country should be engaged in war, and I conceive we ought to provide for the possibility of such a case, how would it be carried on? By the usual means provided from year to year? As our imports will be necessary for the expenses of government and other common exigencies, how are we to carry on the means of defense? How is it possible a war could be supported without money or credit? And would it be possible for a government to have credit without having the power of raising money? No, it would be impossible for any government in such a case to defend itself. Then I say, sir, that it is necessary to establish funds for extraordinary exigencies, and to give this power to the general government, for the utter inutility of previous requisitions on the states is too well known. This must be obvious to every member here. I think, therefore, that it is necessary for the preservation of the Union that this power shall be given to the general government.
Sometimes people don't understand the interplay between the 16th and the 17th Amendments, but I want you to pay attention, if you would, to this next relatively short paragraph from Madison, where he doesn't think that problem is going to emerge. Why? Listen.
But it is urged that its consolidated nature, joined to the power of direct taxation, will give it a tendency to destroy all subordinate authority, that its increasing influence will speedily enable it to absorb the state governments. I cannot think this will be the case. If the general government were wholly independent of the governments of the particular states, then indeed usurpation might be expected to the fullest extent. But, sir, on whom does this general government depend? It derives its authority from these governments, and from the same sources from which their authority is derived. The members of the federal government are taken from the same men from whom those of the state legislatures are taken. If we consider the mode in which the federal representatives will be chosen, we shall be convinced that the general will never destroy the individual governments.
What both the 16th and 17th Amendments reflect is what Madison and others knew would happen when there wasn't an adequate structure to keep people from making stupid mistakes. Those are two of the biggest stupid mistakes ever made in this country, and they were made by majorities in the states. The whole point about a Republican Constitution that Professor Barnett has been talking about is a structure that makes it more difficult to make changes that undermine that structure. So now at this point, let's go to the third session. So in this final section, it's Henry versus Madison on a Bill of Rights. At a certain point in this long ratification debate in Virginia, it became apparent that the Federalists were winning. So Henry has to try to maneuver things in such a way to tie it to a Bill of Rights, the necessity of a Bill of Rights, and try to get the other states to have to affirm a Bill of Rights before anything goes forward. In other words, what they were trying to get was an absolute condition on ratification. That gets beaten, however, and it's really important because had it not been beaten, then the whole thing might have become unraveled. Instead, what Madison and others do is to agree that when the Congress convenes, that they will go forward with a Bill of Rights. And that's what happens when Madison actually gets to Congress. Now, interestingly, Patrick Henry wouldn't allow Madison to become one of the senators chosen by the state legislature. But Madison was able to beat Monroe for a seat in the House. And it is there that he puts forward the Bill of Rights, and it goes through a certain process, and it finally comes out and is sent to the states. It is ratified, yes, and at that point, most of the opposition that still remained to the Constitution evaporates. But it's important to listen to the actual argument that Madison makes. It is a different audience and a different type of argument. There are several parts to Madison's argument, and we're only going to take the first few. The first part, in many ways, the most important part, he has to justify why they should consider the Bill of Rights. You may think that that's obvious, but they're in the business of starting a government. There are a lot of things that they have to create. One of the things in particular are the federal courts and the Judiciary Act. So for many of the Federalists, they think, well, we've won. We don't need to address this. Now, Madison has to address it. So he has to tell them the many reasons why. That's going to be the first part. Then the second part I'll go into after the first part. So let's hear from Madison in this opening to try to persuade his colleagues that this is really an important thing to do.
I am sorry to be accessory to the loss of a single moment of time by the House. If I had been indulged in my motion and we had gone into committee of the whole, I think we might have rose and resumed the consideration of other business before this time. That is, so far as it depended on what I proposed to bring forward. As that mode seems not to give satisfaction, I will withdraw the motion, and move you, sir, that a select committee be appointed to consider and report such amendments as are proper for Congress to propose to the legislatures of the several states, conformably to the 5th article of the Constitution. I will state my reasons why I think it proper to propose amendments, and state the amendments themselves, so far as I think they ought to be proposed. If I thought I could fulfill the duty which I owe to myself and my constituents to let the subject pass over in silence, I most certainly should not trespass upon the indulgence of this House. But I cannot do this, and am therefore compelled to beg a patient hearing to have what I have to lay before you. And I do most sincerely believe that if Congress will devote but one day to this subject, so far as to satisfy the public that we do not disregard their wishes, it will have a salutary influence on the public councils and prepare the way for a favorable reception of our future measures. It appears to me that this House is bound by every motive of prudence not to let the first session pass over without proposing to the state legislatures some things to be incorporated into the Constitution as will render it as acceptable to the whole people of the United States as it has been found acceptable to a majority of them. I wish, among other reasons why something should be done, that those who have been friendly to the adoption of this Constitution may have the opportunity of proving to those who were opposed to it that they were as sincerely devoted to liberty and a republican government as those who charged them with wishing the adoption of this Constitution in order to lay the foundation of an aristocracy or despotism. It will be a desirable thing to extinguish from the bosom of every member of the community any apprehensions that there are those among his countrymen who wish to deprive them of liberty for which they valiantly fought and honorably bled. And if there are amendments desired of such a nature as will not injure the Constitution, and they can be engrafted so as to give satisfaction to the doubting part of our fellow citizens, the friends of the federal government will evince that spirit of deference and concession for which they have hitherto been distinguished. It cannot be a secret to the gentlemen of this House that, notwithstanding the ratification of this system of government by 11 of the 13 states, in some cases unanimously, in others by large majorities, yet still there is a great number of our constituents who are dissatisfied with it, among whom are many respectable for their talents, their patriotism, and respectable for the jealousy they have for their liberty, which, though mistaken in its object, is laudable in its motive. There is a great body of the people falling under this description, who at present feel much inclined to join their support to the cause of federalism, if they were satisfied in this one point. We ought not to disregard their inclination, but on principles of amity and moderation, conform to their wishes and expressly declare the great rights of mankind secured under this Constitution. The acquiescence which our fellow citizens shew under the government calls upon us for a like return of moderation. But perhaps there is a stronger motive than this for our going into a consideration of the subject. It is to provide those securities for liberty which are required by a part of the community. I allude in a particular manner to those 2 states who have not thought fit to throw themselves into the bosom of the Confederacy. It is a desirable thing, on our parts as well as theirs, that a reunion should take place as soon as possible. I have no doubt, if we proceed to take those steps, which would be prudent and requisite at this juncture, that in a short time we should see that disposition prevailing in those states that are not come in, that we have seen prevailing in those states which are.
In this next section, Madison has to assure his colleagues that the changes that will be made will be beneficial, but that they're not very radical. They don't fundamentally change anything. But that, after all, is what Henry and some of the other leaders wanted. They want it back to a confederation. They want a statement in what we know of as the 10th Amendment that powers that aren't expressly given to the federal government are held back by the states and the people. That word expressly is not in there. That's critical in terms of understanding what the Bill of Rights does and doesn't do. Let's hear more from Madison.
But I will candidly acknowledge that over and above all these considerations, I do conceive that the Constitution may be amended. That is to say, if all power is subject to abuse, that then it is possible the abuse of the powers of the general government may be guarded against in a more secure manner than is now done, while no one advantage arising from the exercise of that power shall be damaged or endangered by it. We have in this way something to gain, and if we proceed with caution, nothing to lose. And in this case it is necessary to proceed with caution, for while we feel all these inducements to go into a revisal of the Constitution, we must feel for the Constitution itself, and make that revisal a moderate one. I should be unwilling to see a door opened for a reconsideration of the whole structure of the government, for a reconsideration of the principles and the substance of the powers given, because I doubt, if such a door was opened, if we should be very likely to stop at that point, which would be safe to the government itself. But I do wish to see a door opened to consider, so far as to incorporate those provisions for the security of rights, against which I believe no serious objection has been made by any class of our constituents, such as would be likely to meet with the concurrence of 2/3 of both houses and the approbation of 3/4 of the state legislatures. I will not propose a single alteration which I do not wish to see take place, as intrinsically proper in itself, or proper because it is wished for by a respectable number of my fellow citizens, and therefore I shall not propose a single alteration but is likely to meet the concurrence required by the Constitution. There have been objections of various kinds made against the Constitution. Some were leveled against its structure, because the President was without a council. because the Senate, which is the legislative body, had judicial powers in trials on impeachments, and because the powers of that body were compounded in other respects, in a manner that did not correspond with a particular theory, because it grants more power than is supposed to be necessary for every good purpose, and controls the ordinary powers of the state governments. I know some respectable characters who oppose this government on these grounds, but I believe that the great mass of people who opposed it disliked it because it did not contain effectual provision against encroachments on particular rights, and those safeguards which they have been long accustomed to have interposed between them and the magistrate who exercised the sovereign power. Nor ought we to consider them safe while a great number of our fellow citizens thinks these securities necessary. It has been a fortunate thing that the objection to the government has been made on the ground stated, because it will be practicable on that ground to obviate the objection so far as to satisfy the public mind that their liberties will be perpetual, and this without endangering any part of the Constitution, which is considered as essential to the existence of the government by those who promoted its adoption.
Well, Madison didn't really have an easy time getting the Bill of Rights through the Congress because it was dominated by Federalists, and they weren't really concerned about our Bill of Rights. Remember, they were opposed to a Bill of Rights. Even Madison was really opposed to a Bill of Rights. And you could say that pragmatically, he had to promote a Bill of Rights because he had to get elected from a district that wanted the Bill of Rights. And he promised it, so he should carry forward with it. But there's one very important point here, and that is that Madison understood that it was not just good enough to win. Yeah, they had won, but what was needed for this new government was support, the support of everyone united in believing that it was protecting their liberty. Without getting rid of that sense that it wasn't, you're going to have an undercurrent that undermines the legitimacy of the government. And so his argument is heavily that this Bill of Rights won't do any damage, but it'll do a lot of good. It'll bind people to the Constitution. Why won't it do any damage? Well, the damage that the Anti-Federalists wanted to do was a provision like in the Articles of Confederation, saying that all powers not expressly given to the central power were reserved to the states. And that exact language is not in the 10th Amendment. It looks like it, but it leaves out the word expressly. That's critical. And we'll see that that comes to play later on when we go over the argument about a national bank, long before the McCulloch case itself. I want to end this section by referring us back to a clip that I played in an earlier session from Justice Scalia, just a part of it where he is talking about the Bill of Rights.
If you think that a Bill of Rights is what sets us apart, you're crazy. Every banana republic in the world has a Bill of Rights. Every president for life has a Bill of Rights. The Bill of Rights of the former evil empire, the Union of Soviet Socialist Republics, was much better than ours. I mean it literally. It was much better. We guarantee freedom of speech and of the press. Big deal. They guaranteed freedom of the speech, of the press, of street demonstrations and protests, and anyone who is caught trying to suppress criticism of the government will be called to account. Whoa, that is wonderful stuff. Of course. Just words on paper. What our framers would have called a parchment guarantee. And the reason is that the real constitution of the Soviet Union, you think of the word constitution, it doesn't mean a bill, it means structure. Say a person has a sound constitution, has a sound structure. The real constitution of the Soviet Union, which is what our framers debated that whole summer in Philadelphia in 1787. They didn't talk about the Bill of Rights. That was an afterthought, wasn't it? That constitution of the Soviet Union did not prevent the centralization of power in one person or in one party. And when that happens, the game is over, the Bill of Rights is just what our framers would call a parchment guarantee.
The great irony is that when Madison proposed the Bill of Rights, at least a number of them, if not all of them, were intended by him to be inserts in the existing text. In other words, there would not have been a separate, quote, Bill of Rights. It simply would have been part of the text. Now, that might have looked a little bit messy in the sense that certain words had to be dropped and the new words put into the text. There'd have to be a new text. They had signed the original text where they have to do another signing. In any event, his colleagues did not want to do it that way. In fact, for some of them, it was, you're messing with the perfection that we had created. So they added it afterwards. Now, that is where they made a tactical mistake, you might say. But for others, you would say it was perfect. Either way, it is distinct in that the first 10 amendments are referred to as the Bill of Rights. The downside is that for many Americans, the real Constitution is just the Bill of Rights. And for progressives, that together with the 14th Amendment allows them to give very reduced coverage, if any, to the structure of the Constitution, making the argument of Henry and a lot of the Anti-Federalists that really the structure is not a good thing. Justice Scalia's point is the structure is the main thing, and that the Bill of Rights, as he often said, is the icing on the cake. But without the structure, in particular, an independent judiciary, those rights are going to be mere parchment barriers that can be easily overcome by those in power. Earlier today, I got an email from one of the students asking me to be more specific on the readings. When the readings are from one of the three books, I'll put up the pages and we can't copy those books as I've indicated before. The other readings are almost all online, but the difficulty is that many of the readings are very long. So as you can tell, I've only been using excerpts from certain of the readings that are assigned for that week. So right now I'm going to put up the readings for this coming week and be more specific about it. And at the end, we will put this in the notes that follow on Zoom, and also it will be available on the event page on the Federalist Society website for the upcoming week session. So next week, we're going to carry over the Burke-Paine debate that I said we would carry over. And you can see here I've got excerpts because they're both very long. So I'm going to take excerpts from each. And the link I have are to certain excerpts. In addition, there are pages there from the Ethics of Rhetoric. You can get to it. That's important simply because the author is going after the type of argument that Burke's using. And he's rather critical of it. And I think it's important for conservatives to understand what this great conservative rhetorician thinks about the type of argument that Burke is using. So after that, we're going to go into Washington's farewell address. That's available online, and it's very long. So I'm not going to go through the whole thing. If you're reading it in its entirety, if you want, you can skip the opening part because it's a very genteel approach to his audience, typical of the 18th century. But the substance obviously comes after that. Finally, in the debate over the Bank of the United States between Hamilton and Jefferson, both of their letters to Washington are available at Founders Online, which is a website for the National Archives. So it's just a reference to that. And then I have some pages from, as well, Novus Ordo, because these pages relate to Washington and in particular his character and how that was influencing his decisions. So thank you again for joining us tonight, and hope you will join us again next week.